Welcome back, everyone. Interesting story about my guest. Going back better part of 10 years. And I called up Kate Hogan and said, Kate, hello, Alicia with a speeding ticket. And Kate, knowing me and knowing my personality, said, I have exactly the right person for you to talk to. And that's Greg Canale. And over the course of 10 years, I've gotten to know Greg and followed his career. And now Greg is running for Warren County Court Judge and Surrogate. And I asked him to come on to just talk about why he wants to run for that position, and amongst other things. So hello, Greg. How are you?
Hi, Jesse. So nice to be here. Thank you for having me.
Oh, you're quite welcome. That's quite a title there, Warren County Court Judge and Surrogate. What does that mean?
Well, you, as a county judge, you adjudicate all felony cases. So it's primarily the felony criminal court of our county. It has jurisdiction over all felony cases in the county. And it's also the surrogate court, which deals with all the probate matters, the wills, the trusts, all the state matters. So that's where you go to get your will probated or to challenge a will or a trust.
Got you. That's quite an extensive list of responsibilities. You've been a trial lawyer, I think you told me, it's the better part of 30 years. I can't imagine isn't anything that you haven't seen, right, in the courtrooms. And you'd made a statement that I just wanted to ask you to follow up on. You said that you were running because you wanted courts to be more responsive. You wanted to be more transparent. What's behind that thinking, Greg?
Well, in the 30 years of practicing law, I've seen a lot of things that take place in court that it's hard to explain to your client. One of the things is when you go to court and you conference a case, you tell your client, hey, we're gonna meet the court, we're gonna meet the judge, we're gonna have a court conference. Much to the surprise of the client, the parties are put in a private room and the lawyers are brought into a judge's chamber where the case is talked about outside the presence of the client. And then you go back to the room and you tell the client, this is what the judge said, this is what happened. And of course, they're baffled. They're like, well, did you tell the judge this? Did you tell the judge that? What did the judge say about this? And I understand the mentality behind this. They think that you can get a lot more done if you conference the case with your lawyers who are going to charge with the duty of zealously representing the client. The clients may just get in the way, or there might be too many emotional outbursts. But I don't think it's right. I don't think it's fair. I think parties have a right to be present during court conferences, to know what the judge is thinking, to know how your lawyer is advocating for that client. And so the client gets a feel for the case, the texture, what issues the judge feels are important, and it would just be much more transparent. That's the transparency part. The responsiveness, I think, the courts, have failed to be responsive to the needs of the community. One perfect example is the opioid epidemic has increased over the time. And yeah, our treatment court, although it's a beautiful, wonderful program, and Judge John Hall does a wonderful job, it hasn't changed in 20 years. And there's a lot of ideas I have that I want to initiate in county court having to do with improving the treatment court program. So we need to be more responsive. We need to be more proactive with the treatment court program. And I think there's a lot we could do to do that, for that to be resolved. So there's a lot we can do. As far as the treatment court, I have proposed starting a jobs training program for people who go into the treatment court, who have no career, no skills. I would like to bridge these people, connect these people with local plumbers, electricians, artisans, bakers, chefs. It'd be wonderful if when they successfully complete their treatment program, they had a skill, some craft that they could use to get employment. There can be no greater bulwark against slipping in your recovery program than the dignity of labor. It goes so far in helping you obtain and preserve sobriety. I want to make sure that everybody that fully graduates from treatment court has a job or has a great outlook for a job. And that's why one of the things I propose, they do it in Washington County, it's very successful. If you successfully complete the treatment court program, I'd like to either seal your felony conviction or at least replace it with a misdemeanor conviction. I don't know how we can ask these folks to go out into the job market, rejoin the citizenry, and lock them out of the job market with a felony conviction. It's very difficult for people to get work, employment, when they have this felony conviction.
Well, you know what you know what you're talking about there. This is a key point, Greg. If you look at our judicial system, people tend to think of it in terms of punishing the individual, but what you're really talking about is rehabilitating the individual. And toward that end, every single thing you're saying to what's on their permanent record, how is it? Is it a felony? Is it a misdemeanor? If they successfully live up to their end and go through recovery programs or whatever, do they deserve a second chance? Do they deserve the opportunity to redeem themselves? And I really applaud you for that, because I think that that's a really progressive but important way to look, to look at this position. I want to ask you about some of your ideas, but I made a note, and I know I would forget. I had talked to Jason Carasone about this. The Bail Reform Act is just something that a lot of people are very concerned about. They don't really understand it. What's your position on that?
Well, I think the Bail Reform Act has some good points and it has some bad points. I have seen how the bail system can work terrible injustices on people. I have seen people incarcerated for 6 or 7 months before they get their day in court, and then when the district attorney finally opens up the file and realizes it's a weak case, they say, if your client pleads to the charge, time served. But when you bring that kind of proposition to someone that's been wrongfully incarcerated for 6 months, they're apt to take that deal, even though they didn't commit the crime. They're just so anxious to get out of jail. They're going to plead guilty to a crime they haven't committed. And this happens a lot more frequently than you think. Cash bail has worked a grave injustice on people. They lose their jobs. They can't support their families. This is for low-level misdemeanor crimes, things of that sort. I do think that if somebody's charged with a high-level felony offense and they don't live in this area, and there is some indication that they would perhaps not return to answer the charge, I do think the judge should have retained some discretion to post some cash bail to make sure that defendant appears. So I think all in all, the Bail Reform Act has achieved a lot of good. It does need some tweaking, and I believe there's a bill in the Senate right now to reinstate some discretion to the trial judges in matters like that, serious felony matters.
Yeah, I agree with you. I think that there were some good points to that bill. And of course, that tragedy that happened up at Exit 25 just highlighted the fact that you have to be very careful of the loopholes in something like this. And also, I think the other thing that you'd agree with is that the court situation downstate is different than the court situation upstate in terms of capacity, in terms of the severity of the crimes, and a lot of issues at play there. But not something that can either be voted on an up or down. It needs work.
Well, that's a great point, Jesse. There's an incredible cultural difference between New York State, upstate, and the city. And I think the judge needs that kind of flexibility to take those cultural differences into account.
Mm-hmm. Here's a question for you, and feel free to run with this a little bit, Greg. Being a judge is one of the most revered positions in our judicial system. And, we happen to be in a time where politics is so divisive, lack of respect for rule of law. A lot of these cases can be made, and there's a lot of arguments both sides. I recognize that. But you made the decision to run for this office. It's a really revered office. Why did you decide to do this?
Well, obviously, the first and foremost reason is community service. This county, I was born and raised in Warren County. I love the people of this county. They've been incredibly wonderful and supportive to me. And I'm coming into the tail end of my career. I've spent 30 years learning the trade of law and trial advocacy. If I can have the opportunity to return the wisdom and lessons I've learned from the multiple years of trying cases and representing ordinary people with ordinary legal problems, if I can help extricate them out of the judicial system with a sense of justice, I think that would be a wonderfully gratifying give back to the community. But I am concerned, just as many citizens, about the divisiveness that's taking place in our society, where white is black, where night is day, and where facts don't seem to matter. I find that the courts are the last bastion of hope for a place where people can count on, where facts matter, where reason and logic matter, where facts have to be established by evidence, where opinions have to be based on science, where personality, politics, attitudes, they're all irrelevant. The only thing that's relevant in a courtroom is the facts of a case. And you can't stand up in court and point out the fact that someone's a liberal or a conservative or a Trumper or a snowflake. It's completely irrelevant. I want the courts to preserve that wonderful place that we hold in our democracy, where the only thing that matters, not personality, not income, not power connections, the only thing that matters is the truth based on evidence. That's why I want to run for judge, because I want to help preserve that last bastion of hope for our democracy.
Well, that's quite an answer there, Greg. I'll tell you. I can tell that you've not only thought about that, but that you live it. That's very, very interesting. I'm sure our viewers are finding that very insightful as well. Hey, what line are you running on, and when is the election? We forgot some of the structural stuff here, and I want people to know.
So the primary is June 23rd. You can obviously vote by absentee ballot, which is being encouraged. You just call the Board of Elections and ask them for an absentee ballot. I'm running as a conservative Democrat, a North Country Democrat. I've been a Democrat my whole life. My father was a Democrat. But I'm a very conservative Democrat, which you'll find most Democrats in this area are. I've been endorsed by the Conservative Party, primarily because of my 30 years of trial advocacy. So I'm running for the conservative line. I've been endorsed by the Conservative Party, and I'm running for the Democratic line. I hope that if I get both of those lines, I stand a good chance of competing with the Republican candidate, which that would be a great contest.
Boy, I agree with you, and you're right about striking that balance, and especially in the up where we live. And I think that is the balance to strike. By the way, you know.
Yeah,
so.
There's a lot of cultural difference in upstate New York. That's one of the reasons why, talk about the Second Amendment for a second. A lot of people want to know about the Second Amendment and what my stance is, because this community has a very rich tradition of hunting and target practice. I will issue unrestricted carry and concealed permits, and the reason I'll do that is because of the tradition of this county. We have a very safe history record of weaponry in this county, and you have to go through a rigorous background check in any event. Now, this isn't just a talking point to me, Jesse. I've represented clients multiple times in court advocating the wrongful and arbitrary denial of their pistol permits. I know a lot of other candidates are for the same thing, but I've been advocating for Second Amendment rights since I've been an attorney. I represented the first person charged with a violation of the SAFE Act on constitutional grounds. I believe people have a right to keep and bear arms. I believe in the majority decision in the Heller case. So it's all boils down to a person living and being born and raised in Warren County and knowing the cultural differences of upstate New York. And I do. I've been living here my whole life.
Well, Greg, I'm really glad to talk to you. Go to the Board of Elections, find out when the primary is, make sure that you vote. And Greg, it's great catching up with you. And thank you for 10 years ago for that little thing that I needed help with. But it was a pleasure to get to know you as a result of that. So thanks a lot, man.
Jesse, next time all I could say is park a little slower.
Thanks, Greg. You take care.
Have a great day. Thank you.
Goodbye.